Hi, everybody. My name is Samantha Wolfe, and I'm with the law offices of Samantha Wolfe in Waynesboro, PA. And here today, we're going to talk about estate administration. So I'm going to go ahead and share my screen because I do have a PowerPoint here for us. Okay, there we go. So we're located at 20 East 6th Street in Suite 206 in Waynesboro, PA. And you can reach us at 717-655-2676. That's just a picture of the front of our office. Sometimes people have a hard time finding us, but we are in the Landis complex. All right, so today we get to talk about easy paths to estate administration. The reason why Amy and I picked this topic is I have a good friend of mine and some clients who live out in Altoona, PA. And I would say once or twice a month, I'm headed out to Altoona to meet with clients. And the quickest way for me to get there is to jump on the turnpike. And I don't know here if anybody has been on the turnpike recently, but they have stopped using the tolling plazas. So you can just drive through, and they then either, if you have an easy pass, they do it that way. Or if you don't, they send you a bill in the mail that you then pay. And so I spend a lot of time thinking about easy passes and whether or not I should get one, should I not get one. And so when Amy and I were brainstorming topics for our virtual seminars that we have once a month, it came up about easy pass to estate administration. When you have an easy pass, it makes it much easier, at least before they stopped tolling, for you just to go through those tolling booths, just run on through, and it took care of all of that for you. So we wanted to kind of give a crash course in estate administration. Now, we've done a virtual seminar about estate administration in the past, and you can find that on our YouTube channel. If you would pull up YouTube and just type in the law offices of Samantha K. Wolfe, or we also have it on our Facebook page, and you can find it on there as well. If you were to look for it, you would find a whole virtual seminar that we did about estate administration. And so it has a lot of different information than what we're going to talk about today. So today I wanted to give more, I don't want to say nitty gritty, but just more kind of where the rubber meets the road guidance about how to administer estates and how we do it here at our office. And I really wanted to give some examples of things that we have been dealing with in the most recent months, as well as when I practiced in Williamsport for a while, we dealt with estates up there as well. So just kind of giving you some practical advice about estate administration, kind of guide you through that. So that's what I plan to do for the next hour, or close to an hour. And like I said, I'm going to answer any questions that anybody has at the end. We do have the chat box, as well as you can unmute yourself at that time and ask the question. I'd be happy to field that. So with that being said, let's proceed with the easy path to estate administration. So I think the first thing, and some of this is going to be a review from the last virtual seminar, but we can't talk about specifics unless we lay some groundwork. So I wanted to talk about what is the probate estate. And the reason why this is different is there are actually two categories when someone passes away. There's the probate estate, and then there's the non-probate estate. There's a lot of questions about, well, what's in the probate estate, what's not in the probate estate, what do I have to pay tax on, what don't I have to pay tax on? So I wanted to guide you a little bit with that. So the probate estate is going to be any asset that does not have a beneficiary designation. So the best example is like retirement or life insurance. Retirement, life insurance, an annuity, any other type of asset where there's a beneficiary designation on it, that's going to be a non-probate asset, which just means probate is the process by which we go to the courthouse. Or at the end, I'm going to talk about virtual probates and how Tammy and I have been dealing with that in recent months. But typically it was, we would go to the courthouse where the person who passed away, where they lived in their county, we would go with them to the courthouse. They would get sworn in, they'd pay a filing fee. It didn't take real long, but what that gave us was the grant of letters and the short certificate. And that was needed, or is needed, to provide to institutions when you're asking for date of death values, as well as when you're closing accounts and shifting it from the estate into the beneficiary's name. So that's kind of the probate process. Only assets in the probate estate have to go through that process. But it's important to note that even if you don't have to go through that process, it still may be subject to tax. So just like anything with the law, there's no clear cut, if you have this, you don't have to do probate or avoid tax. There's always going to be something that we're dealing with when someone passes away. So the probate estate is going to be anything without a beneficiary designation, anything that doesn't have a joint owner. So for example, and I use my family a lot in my examples here. So for example, if my sister and I owned real estate together, if it said Jess and I owning some real estate, then when I passed away, that would go to her if the deed states that we had a right of survivorship. So that wouldn't be in the probate estate. Doesn't mean she's not going to pay tax on it. It just means that she doesn't have to go through the executor and have an executor appointed in order for her to receive the real estate upon my death. And then the third category of assets is anything with a transfer on death, that's what TOD means, or pay on death, that's what the POD means. So any asset that doesn't have a transfer on death or a pay on death designation, that's going to be a non-probate asset. So again, you can have assets that pass without probate, but you're still going to pay tax on it. Probate is just the process that you go get the executor appointed and then administer the assets by the will. So the will is kind of the directing force when you have a probate estate. If you have a non-probate estate, it's going to be the beneficiary designations or it's going to be a trust. So a trust is also a non-probate asset. So having that foundation, now we can move on to the next concept, which is if we don't have probate, are there still other administrative tasks we have to do when someone passes away? And the answer to that is yes. So even if we don't have to go through probate, maybe we have assets owned in a trust, maybe we have beneficiary designation, maybe we have a joint owner. Regardless of the situation, there's still other administration that we're going to have to do. So when we're talking about our easy path to estate administration, the first thing I think everybody needs to understand is that just because you're avoiding probate, it really doesn't mean that there's not going to be additional administration. And like we talked about in our other virtual seminar, in Pennsylvania, the probate process isn't that expensive. It's not that costly, and it really doesn't take that long to do. But even if you don't have probate, if you have non-probate assets, there's still going to be administration. So here are a couple of dates to remember, and these are all dates that we discussed in the other virtual seminar. So far, this is just kind of a rehash of what we have talked about before we get into the new aspect of things. So a couple of dates to remember is that the Rev 1500, which is the form that you disclose assets on and then pay the Pennsylvania inheritance tax. That's what the Rev 1500 is. Just like you, for income tax purposes, you file a 1040. This is the form for Pennsylvania purposes in which you disclose the asset, the value, and then you indicate what rate of tax that you're on. And just so everybody is clear, if it's going to a spouse when you die, the rate of tax depends on the relationship to the person who died. So if when you die, everything goes to a spouse, there's 0% tax. If it goes to a direct lineal descendant or an ancestor, so if I would pass away at this point, I don't have children, I don't have a spouse, my estate, if I don't have a will, or even if I do, might go to my parents, and they're going to pay 4.5% tax. So if you think about it from where you are, if you go up or down your family tree, or your line of descendants or ancestors, they're going to pay 4.5% tax. Siblings, so if my will leaves everything to my sisters, I have 3 sisters, they're going to pay a rate at 12%, and then everybody else pays at 15%. Now, a couple of exemptions from that: charities don't pay tax, we don't have to worry about that. There are a couple of carve-outs in Pennsylvania, so life insurance death benefit proceeds are not subject to tax. Family farms, if they meet certain requirements, and family businesses, if they meet certain requirements, they aren't going to be subject to tax either. Even still, you're going to disclose them on the Pennsylvania inheritance tax return, which is the Rev 1500, and you're going to explain why it's not taxable. So you're disclosing everything and submitting it. Prepayment, which just means that in our office, we try really, really hard. It is our absolute goal to make sure that we're prepaying the tax, which just means when you have to file the Rev 1500, you have to file it within 9 months of the date of death. But if you pay the tax within 3 months of the date of death, then you do get a 5% tax or 5% discount on the tax that's owed. So if I prepay within 3 months, but I don't have to file it until 9 months. That's the tricky part. So in our office, Tammy and I usually do kind of a draft of the Rev 1500 so we can calculate the tax, make sure that we're getting as close as we can so we can prepay it within the 3 months of date of death. And then the last date that's important to remember is that when you have an estate, a probate estate, you have to advertise, and you have to advertise it in a paper of general circulation. So here in Waynesboro, that would be like the Record Herald. Sometimes it's the Public Opinion, whatever is the general paper of circulation. And then you have to publish it in one legal journal, and you have to do that for 3 weeks. And 1 year from the date the first advertisement is run, then no creditors can come forward. Now, I do want to stop because Tia and I are dealing with an interesting case where we have an estate where the personal representative or the executor, as we would call them, knows that there is this creditor out there. They know there's this medical bill that's out there. We haven't gotten the bill yet. We're waiting for it, but we're running right up against the 1 year of advertising the estate. And so the question becomes, do we still have an obligation to pay that debt? And the answer to that is yes, because Pennsylvania statute says any claims that the personal representative has knowledge of. So we know it's out there. We did get a phone call. We've talked to the medical facility. And so there's a lag time with them getting us something in writing. And I want to say it's the 19th, somewhere around there is our year, but because we know about it, that's what the statute says. So it's 1 year from the date of the first advertisement, anything that the executor knows of out there. So again, this is still all review, so bear with me. We haven't gotten to anything new and exciting yet, but we will here in a second. So probate versus inheritance tax, this is what I had mentioned before. Just because you don't have a probate estate doesn't mean that there's no Pennsylvania inheritance tax. So you can have a complete non-probate estate, and Tammy and I are working with a couple of those right now. We still have inheritance tax that we're dealing with. So we still have the prepayment deadline of within 3 months, and then we have to file the Pennsylvania inheritance tax return within 9 months. Always file the Rev 1500 for retirement, even if the surviving spouse is the sole beneficiary. So a lot of times we'll have where husband or wife dies and there's retirement, and that's the only reason that we have to file the inheritance tax return. But the Pennsylvania statute does say that even though there's 0% tax, you still have to disclose the date of death value on there. So yes, so that's always fun to explain to our clients. Okay, intestate rules. So now here we're getting to something new and exciting. So I know everybody's excited about that. So let's go into that. I'm just checking here because okay. So intestate rules. The first thing is that if we have a surviving spouse, so I'm going to take my parents, for example. Let's say that my dad passes away, okay? And let's say he didn't have a will. That's what intestate means, is that there is no will. So if we have an intestate estate, my dad doesn't have a will, he does, because we actually did it for him not too long ago. But let's just say he doesn't have a will. So if you don't have a will, then you're subject to what the Pennsylvania statute says. Those are what we call the intestate rules. So if you have a surviving spouse and no children. So here's the interesting thing. A lot of people think, well, if I don't have a will, everything goes to my spouse. But if my dad did not have a will, my mom would not get 100% of the estate because my dad has issue. So my sisters and I, there are 4 of us. So what would happen is if my dad did not have a will, leaving everything to mom, then my mom would get the first $30,000 and then she'd get half of the remaining estate. So that's what I think a lot of people don't realize is they say, well, it's not a big deal because everything's going to go to my spouse. I don't need a will. And in Pennsylvania, that's not the case. And Tammy and I are dealing with a couple of situations where we had, in this particular case, we had a wife that passed away and didn't have a will. And husband just thought, well, he would get everything. And he's not going to, because the statute says that he gets the first $30,000 and then half of the rest. The remaining amount is going to go, in this case, to son. So if we're talking about my parents, it would be mom get the first $30,000 and then half, and the other half of it would be split between my sisters and I. So again, now this is if my dad did not have a will, And we're talking about his probate estate, which means that it's not retirement. Because again, if retirement, you have a beneficiary designation, that's not probate. If you have life insurance and you have a designated beneficiary, that's not probate. If you have a transfer on death, pay on death, that's not probate. If you have a joint owner, that's not probate. Or if you have a trust, that's not probate. So intestate rules are only if it's dealing with a probate estate and you have no will. If you're dealing with a non-spouse situation, so for example, if I would pass away and I don't have a will, if I had children, they would get 100%. I have no children, so actually my entire estate, if I died without a will, would go to my parents. If my parents had already passed away, they had predeceased me, then it would go equally to my 3 sisters. So what I think is interesting is actually the non-spouse intestate rules make a lot more sense than actually the surviving spouse rules. And that's just because most clients, husband and wife that I deal with, they want everything to go to their spouse. And the reality is PA law doesn't do that. So if you don't have a will and you're thinking that Pennsylvania law will just get it to your spouse, the answer is that that is not correct. It would actually have to be split. So I wanted to make sure we talked about intestate rules. The next thing I wanted to talk about was post-mortem estate planning. So we're going to talk a lot about the nitty-gritties of how to administer an estate. What's important to know is that there are some post-mortem, after death estate planning. So we always recommend here at our office that everybody have a will in order to distribute the estate. Sometimes people don't have a will, and that's problematic. Sometimes people have beneficiary designations, and that doesn't go according to the will. And one of the ways that we're able to do planning after death is with the use of disclaimers. So Tammy and I are working on an estate right now where what the will said is everything goes to the spouse unless the spouse disclaims. And what a disclaimer is in this case, husband could say, I don't want to receive any of these assets under the will. And so as a result of that, then the rest of the will kicks in, and the rest of the will is going to say it actually goes in trust to daughters. That would be what would happen if either husband had predeceased or if husband disclaims. And so in this case, we're dealing with, well, does it make sense for husband to disclaim? And there might be some benefit to that. It might be a situation where we're dealing with nursing homes. It might be a situation where there's some tax benefit to doing that. So just know that you want to make sure when you're meeting with your legal professional, when you're talking with the attorney, that one of the things you talk about is disclaimer. So we always want to plan for everything possible, but just know that post-mortem after death, we can use some disclaimers if we need to get things to a different place. Okay. One more comment about disclaimers. That's why it's so important in your will to have a statement about what happens if somebody would predecease. So in the example that I gave you with husband, what the will says is if they disclaim. The other thing is if it said that if husband had predeceased, because if there's not a disclaimer clause in there, like in this will, so if mom and dad had a will that said, I'm leaving everything to my wife, my dad says, I'm leaving everything to Denise, then my mom could still disclaim. And she could disclaim, and then what Pennsylvania law says is that then it goes, according to the will, they treat mom as if she had predeceased, and the provisions in the will that say what happens if mom predeceases govern how the assets are distributed. So if dad dies, everything said it went to mom, but mom disclaims either all of the assets or some, you can disclaim all or some, then what the will is going to say is, okay, well, if Denise had predeceased, then it goes to the 4 daughters. And when you disclaim, it's as if you predeceased. So that's why it's so important. I know a lot of times when I'm meeting with clients, I'll say, okay, and if this person dies, where does it go? And if this person dies, it's a lot of if that person does die, but some of it's also if we need to do a disclaimer, because again, if you disclaim in Pennsylvania, it's treated as if you predeceased. So it gives us some planning options after somebody passes away if we have all of those contingencies provided in the will. Okay. So this is where we get to the new, fun, and exciting information. So we're going to talk about real and personal property and how to get rid of stuff. So I was trying to think of complications or the things that cause the most discussion when Tammy and I are administering the estate. And I would say personal property is one of those such items. in my own family. So mom and dad for years have collected these series of paintings that focus on the family. It's an organization. They would do these paintings and release them once a year. And so my mom have collected them for years. And every time they would get one, my sisters and I would, I guess, call dibs on the paintings. We're such loving children. We would say, when you die, we want that one. And so it's interesting because although, yes, we care about, the house and those type of things, personal property tends to have the most sentimental connection for people. The other example I can give you is that my dad made some woodworking items. He made some like rocking chairs, some tables, and hope chests for us over the years. And so if I could imagine there ever being a disagreement, not that my sisters and I are going to disagree, but if there ever would be, I would imagine it would actually be over those items more than anything else. So I wanted to talk a little bit about personal property. And so what can you do? So the first thing that you can do is you can actually provide for it in the will. So you can say, this is how I want my personal property items distributed. I'm doing one right now where they're doing a lottery system. So all the personal property in this case is being distributed to nieces and nephews. And the way he's going to do that is a lottery system, and everybody gets to select. I think he has 8 nieces and nephews. So, everybody kind of draws straws in essence in the lottery system, and then you go in order then. So, you'd start with the person who got the priority draw, and you'd go down. And then when you reach the last person, the 8th niece or nephew, then it recycles through the list in that same order. And they would just select items. So you can do something general like that. You can also specifically bequeath things in your will. So I just did one where this was husband and wife, and husband had a child from a prior relationship. Wife had no children of her own, but was really close to her nieces, which I completely understand. And so she selected certain items from her family that upon her death, even if her husband survives her, these items are going to her nieces. And so I thought that was really nice. I just think of my nieces and nephews. Like I said, I don't have children of my own right now. So I know the personality of each of my nieces and nephews. And so I think it would mean a lot for me to specifically bequeath something to them. I think it has a lot of value weighted to it. Now, some people take the opinion of, no, I shouldn't do that. Why would I do that? It might change my mind. And I completely understand that, which we're going to get to under the second item. But again, there is something about when someone specifically remembers you in their will, especially, and I'm happy to do this with clients, if they give some sort of background. So in the example I just gave where the lady was leaving it to her nieces, she specifically said where she got the items. One of them was a grand piano, and her mother had played, and so she had gotten it through her mother. Another was a ring, and it had come, I think, from her great-great-grandmother. And so she had, disclosed that all in the will. You don't have to, but it is a nice thing to do for people to know why you thought of them and how, and, kind of how it got to them. The other way we do it is a personal property memorandum. And honestly, this one probably makes the most logistical sense. This would be where we include something with the will. It's not a line item in the will, but we attach this personal property memorandum where the individual describes the item, dates, signs it, puts who they want it to go to, and that becomes a part of the will. And then, if you change your mind, you can discard that and shred it. If you need to reshuffle items, you can do that without having to do a whole new will. So that's one way to do it. We have some clients that write a letter. So again, it's all about attaching that sentiment to it. And so we've had clients do letters before. A document signed at the bottom is treated as a codicil. So when we're talking about those personal property memorandums, if they have a different date than when you originally executed the will, they would be considered codicils to the will. Post-it notes. So sometimes I have clients say, well, I just wrote a Post-it note and put it on the back of the picture. And maybe it's the attorney in me. I don't prefer that because a Post-it note can be removed. And especially if you're dealing with a situation where you want specific items to go to specific family members, my preference is either the personal property memorandum or to actually put it in the will. The other thing too is we have Sometimes we have clients have collections, so whether it be certain items of jewelry, coin collections. I'm working with a client right now that has a substantial clock collection. And what we're doing there is he's worked with a certain company when he's been buying these clocks. And so in the will, we're not saying that they have to use that company, but we are mentioning it because the executor can, contact that company or another reputable company to be able to help value those items. Because remember, it's not only that we have to get it to the person, we have to have a value, because in Pennsylvania, there's an inheritance tax. So the tax rate is based on the individual who's receiving it and their relationship to the person who died. So we have to get a value because we have to know, well, what's the tax that's on that item? Car titles. So one thing I wanted to mention here is with husband and wife, typically we only want the surviving spouse to drive it. We have a couple of situations where, especially where it was surviving spouse that died and it was going to kids, and kids were driving around this vehicle, and you don't want to do that. You want to make sure that the title has been transferred properly and that insurance has been issued properly. So I wanted to make sure about the car title. Now, here in this area, Tammy and I have worked with a couple of tags and title companies, and they have been really nice because we had one situation where we would not have had to probate. So remember, probate's where you go to the courthouse and get appointed, and we had a vehicle, and that was the only asset that we really had in the probate estate, and we were working with the tag and title company, and they were willing to transfer, in this case, to the sole child who was, the beneficiary. And so we didn't have to probate in order to do that. They just needed a death certificate for the person who had died, and we were able to transfer that. The last thing on here is that I wanted to talk just personal experience, because I think it's helpful for everybody to have that. My grandfather passed away, oh goodness, I think 2005. It's been a really long time. And it sounds silly, but growing up, he had these really big, those 70s glasses, you know what I mean? The real big ones that had like the tinting that you saw. And I have really fond memories of just sitting actually on their porch and talking to Papa on their swing. And so when, as I got older, I said to him, I said, when you pass away, Papa, I just really want your glasses. So when he passed away, my Nana wrapped them up, his glasses, and gave them to me. And so it's silly. I can't wear the glasses. They just sit in my hope chest, but it meant a lot. That I don't know if it was my grandfather had communicated that or if my Nana had decided that, but it means a lot. It wasn't so much that it was the glasses, it was that, he remembered that I had wanted those glasses. So I think it's important. Personal property, like I said, tends to cause the most conflict. And so we want to make sure that we are addressing that if we need to. Okay, so we're going to shift a little bit off personal property. We're going to revisit it when we talk about real estate, because I want to talk a little bit about the mechanics of how we can do that. But I want to do that in conjunction with the real estate because they do kind of work together. So one of the things I wanted to talk about is that you should always be revisiting your estate plan, because sometimes we have clients who their life circumstances have changed over the years. So there might have been a divorce since they did their will. And as a result, there might be like a property settlement agreement, something like that. So we actually, I printed it just so I could kind of show you. We have a statute in Pennsylvania that talks about modification by circumstance, and it talks about divorce or pending divorce. So if somebody passes away and there has been a divorce and they didn't change their will, that person is treated as if they weren't included in the will, almost like a disclaimer. It's as if they predeceased, unless the will shows that they contemplated the fact of the divorce and they still wanted to provide for that person. So that just means they may say, the residue to my spouse, X, and this person, regardless of whether I'm married to them at the time of my death. So that indicates that they contemplated the divorce, and so if they subsequently got divorced, that person would still get the distribution. But Pennsylvania law does say that if there has been a divorce, then they modify the will so that they're no longer provide that divorced spouse is no longer a beneficiary. And that could be if there is I get questions sometimes, does it matter if there's no decree of divorce? And what it says is that you have to have established the grounds provided for divorce. So you don't actually have to have the decree, but you have to have established those grounds. You have to be that far in the process in order for you to be able to modify for that. The other thing is if the testator marries after making the will, then the surviving spouse is going to be receiving what they would have received if they had died intestate. So I'm not married, but let's say that I created a will and then I got married after that. So what the law is going to say is that my spouse, my newly married spouse, would get what they would receive under the statute. So remember, if I have no kids and I'm married, they would get everything. But if I have kids, they'd get the first $30,000 plus half of the estate. So if I got married after, they would still be provided for. Now, again, this is all unless I show that I did this will in contemplation of the marriage. So if I did the will and I said, and if I ever get married, I don't want to provide for my spouse, then that's fine. Okay, then they're not included. Birth or adoption are also there. So again, if sometimes we have clients who say, well, if I specifically name my children, which I tend to just say equally to my surviving descendants, which would account for any children I have at the time of my death. But sometimes clients want to specifically mention a beneficiary or their children. And so if you subsequently had any, then those children would also be included. Okay. Now let's talk about the tangible personal property. It's kind of a revisiting to when we talked about distribution of personal property, but I wanted to kind of shift this. We're going to head towards real estate. Okay, so there is a method to my madness. So if you have tangible personal property, how do we deal with that? So the first thing is that you have to have an appraisal for anything of value, because we're going to disclose it on the inheritance tax return and the person has to pay the tax on that amount. You can use the garage sale value if it's not something that you know has a value. So that just means, sometimes when Tammy and I are dealing with an estate and there's not like old furniture, it's just generally here are the household furnishings, and we maybe say, okay, well, we would sell it off for $5,000, and we might include that as the value on the inheritance tax return. Next thing is the safe deposit box. Oh, the safe deposit box. So here in our office, safe deposit box are not our favorite thing. It's not that we mind administering them. It's just that Pennsylvania has instituted these odd rules. So let's just say my mom and dad had a safe deposit box, okay? And let's say it was in both of their names. That's fine, not a problem. But let's say my mom is the surviving spouse, and when she dies, what that means is that we now have to inventory the safe deposit box, which just means we have to disclose everything that's in the box. The other thing that we have to do is we have to give 7 days notice to the institution where the box is held and to the state of Pennsylvania before we're allowed to enter the box. We have to tell them what date we're actually entering it and give them 7 days notice. And then after that, we have to give the inventory. So a lot of times clients can take the same items that they kept in their safe deposit box and keep it in a safe or in a fireproof box at home. They can make other means. So if that's something where you have a safe deposit box, or you're thinking about it, or you know somebody who has one, just want to think through the logistics of what that means. If you have a safe deposit box and you do keep your will in there, there is a permission that allows you to enter the safe deposit box, but to get the will, to see if there's a will in there. The next thing is that we want to talk about in-kind distribution. So in a will, for example, if somebody doesn't say a preference, so let's say my dad says, I want everything distributed to Denise, my wife, and then upon her death, equally to my 4 daughters. The question becomes, are we receiving the assets themselves, or is there going to be a liquidation and then a distribution? So in our documents, unless we have the discussion with the client and they say, we specifically want something liquidated, or we specifically want it distributed in kind, the executor has the flexibility. So they have the option to distribute in kind or to liquidate. That's actually really helpful, especially when it comes to real estate, because sometimes the market with real estate is up and down. So if we can distribute in kind, we can distribute equally out to my sisters and I, and not necessarily sell it right away. We can hang on to it, wait for the market to rebound, and then sell it. So if you don't have a preference, typically we allow that flexibility. We also can reduce the beneficiary's share based on a value as appraised. So sometimes we may say the primary residence goes to me, but then my share is reduced by the value of the house. Okay, so you can do that in the will. Expenses for storing, delivering, and etc. is an expense for the estate unless the will provides differently. And then how are taxes paid? So this should always be covered in the will. You can either have it be out of the residue or it can be allocated to the bequest. Now this makes a difference if you have specific bequests. So if my parents, for example, wanted a bequest to, let's say, their grandchildren, they wanted each grandchildren to receive $50,000, for example, does the tax come out of that $50,000? So it's $50,000 minus the tax that's paid on it, or is it they get the $50,000 and then my sisters and I are paying the tax on everything? Okay, so you want to make sure that you're thinking through that, because if you're thinking, oh, I'm going to leave all of my residuary beneficiaries, meaning that once all the specific bequests have happened, these people get the rest of everything, their share, the rest of everything could be reduced by the amount of taxes. So you just want to think through that as to who pays the taxes. So if there's property with no value, we think family pictures, clothing is another example. You might want to have the family come together to clean the house. If there's a lot of assets or a lot of things you're going through, we have a couple of instances where clients have stored things for a really long time. And so there's a lot that has to be gone through. You might want to get a dumpster to do that. Our office has had great success with auction companies. We use auction companies here, and that's effective for a couple of different reasons. Sometimes we have real estate that we want to sell as is, and we don't want to have to go through like a real estate agent and have all of those inspections and all of that. We might want to sell as is. Or, if there isn't anybody else. So in one case, the person who passed away had no children. It was all going to family friends. And so, they were just like, let's just go through a local auction company. We've had a lot of great experiences, Tammy and I have had with Hurley auctions. And so great experiences both with personal property and with real estate. I'm sure there are other great companies. We just, because of where we're located, Hurley's has been the one that we've used predominantly. And Tammy and I have done the real estate that way, and we've also done personal property that way. We've had great experiences with them. So we can always make that connection there and walk you through that if you would need help. And how do you handle minors? So the personal representative has to hold or give to the guardian of the minor until 18. So we always like to address with our clients a custodial clause in the will. So who is going to hold these funds? Because otherwise it's going to have to be the executor. And then the other thing I like to bring up is sometimes I will have clients come in that already have a will, and it's like a 2-page will or a 1-page will. And, they're thinking, well, what's the point of having a longer will? Well, the point is that we include clauses in there that allow the personal representative to create a trust if we have a beneficiary with supplemental needs, or they can create an ABLE account, which is an account specific for a beneficiary with special needs. It might help when we're talking about certain benefits. And so we want to allow our personal representative to do that. So our language says anybody with a special needs, a disability, or incapacity, the personal representative can create a trust for their benefit. So you want to make sure that your will has something in there. You never know what's going to happen. Firearms. So here in rural PA, we have some clients that have like gun collections. And I would say that this is the biggest item that clients are not knowledgeable about when it comes to how you're passing them. Certain firearms, so there's a federal list. Certain firearms, only certain people can handle. It's somebody that has a license. So if we have clients that have firearms on that list, and let's say they say, my personal property or my guns go to this person, and that person is not licensed, then they can't actually receive them. So the question is, can the beneficiary legally possess the guns that you do have? The other thing is there a reputable gun store or values or procedures that you want your beneficiaries to follow? Like maybe you've dealt with a certain company. It goes back to the clock situation where maybe you've purchased items. And then the last thing is you might need a gun trust, because again, if you want it to go to certain beneficiaries and they can't legally possess it or they can't handle it, or your executor. Here's the other thing. Maybe the person who's going to get it. So let's just say my dad's leaving it to my brother-in-law and he has all of the licenses, but I'm not licensed. I can, as the executor, effectuate that transfer. So it might have to be that the guns that my dad wants ultimately go to my brother-in-law need to be held in a trust where the trustee has licenses to be able to handle those guns. So when we're talking about firearms, sometimes we use what we call a gun trust because we have to appoint a trustee or we have to give requirements for certain licensings that person has to have in order to be able to distribute those firearms. All right, so let's talk about real property. The question is whether or not we have to redeed it. So the answer to that is if it's a spouse. So if it says my mom and dad, Denny and Denise are on the deed, Denny dies, my mom does not have to redeed it just because he died. Because in Pennsylvania, the law is that if you have husband and wife, it automatically goes to the surviving spouse, title vests, and then they own 100%. So you wouldn't need to redo the deed just for that. What would happen is at my mom's death, when we did the deed, we would reference and say, Dennis died this date, Denise died this date, all of that. So we had that in the deed, but you don't have to redeed solely for that. Now, here's the thing. We have had more and more instances where when a client comes in and they want to do something with the deed, we realized in this case that it was in husband's name alone. So at that point, they did need to do something because it didn't have a joint owner. So it had to go through probate. And so we need to make sure that you're checking the deed, does it have both spouses on it? If not, then probate would have to happen. So we've had two instances, one where mom wanted to do some planning, some nursing home planning, and we realized that deed was in dad's name alone. So we now have to open an estate for dad to get it to mom in order for her to do the planning. And then we had a situation where husband and wife died. It was just in her name. There's no will. And so now we're dealing with intestate, which means that the first $30,000 goes to husband and then the rest is split equally. So it's a little bit of a mess there. So that's one thing you want to discuss. You might want to get an appraisal unless you're selling it within 9 months of death, because remember the 9 months is when the return has to be filed. So you can use the tax assessed value times the common level ratio factor and disclose that value on the inheritance tax return, or you can get an appraisal. Or you might be selling within 9 months and then you use the sale price. The reason that you might get it appraised is that whatever is disclosed on the inheritance tax return becomes the basis for those beneficiaries. So if we use mom and dad die and we use the tax assessed value, in most instances, the assessed value is less than the appraised value. So that would become our basis in the property. If we sell it, it would just mean my sisters and I are paying more capital gains, which is a big deal because the capital gains rate is 15 or 20%. The inheritance tax is only 4.5. So it's just something to think through. You might want to pick the lower value because it's less inheritance tax, but if you're planning to sell it, it may mean more income tax. So you may actually want to spend the money to get an appraisal so you have the highest value on the inheritance tax return. If you're selling it, that's great because you can use the actual sale price and then you don't have to worry about that. The inheritance tax versus the capital gains, that's what we talked about. You have to weigh what's the inheritance tax. Do you want a higher or lower value that you're paying 4.5% on for direct lineal descendants? Do you want the lower value, but then again, the capital gains is higher? So just thinking through those. And we have used auctions to sell real estate, and that has gone really smoothly. If we're dealing with real estate, please note that if the personal representative, the executor, wants to buy it, it does require 2 appraisals, which can be about $500 each, and court approval unless the will specifically allows it, okay? So a lot of wills I see don't allow this, and the personal representative wants to buy the property, and it doesn't provide that, so we have to get court approval. So you want to make sure that if there's a possibility that the person who's serving as the executor may want to purchase it, that you give them the right to be able to purchase it. There's no realty transfer tax if it's going to a beneficiary with no consideration. So if my dad said, upon my death, Denise and I's death, so at the second spouse's death, the house goes to Sam, then I wouldn't have to pay realty transfer tax. Realty transfer tax is that 2% tax that you pay, or 1% buyer, 1% seller. When you're dealing with an estate, you have to pay that too, unless it's specifically bequeathed to the beneficiary, or unless it's part of the residue and it's being distributed out to the residue, then there's no tax. In the case that Tammy and I are dealing with right now, though, it gives an option to purchase. an option for purchase means that there's going to be realty transfer tax because it's not specifically bequeathed to somebody and it's not part of the residue. It's this person has the right to buy it, they're going to buy it, and so there's going to be realty transfer tax. So one thing that you can consider doing is if you're the executor and you want to buy it, you might want to renounce. If there's nothing in the will that says that you can do it without court approval, you may want to renounce so that you can buy the property. Open market sale, you can do that with, listing it with a real estate agent, or you can do it with auction as is. We've had a lot of great success with that. It works really well, so that's another option. Estates don't need the seller's disclosure form. If the personal representative is not at the closing, you can get the power of attorney to sign documents at closing. I've done that a few times where somebody was out of state, so they gave me the ability to sign all the closing documents, and I went to closing and signed for them. A tip is that another thing is that you might want to include the option to purchase in the will, as well as in the will, you might want to have digital asset language. That's something new that came out this year too. So I put this in as a tip because both of these things, real estate and digital assets, you have to specifically provide the person the option in order for them to be able to do it. Mandatory mediation. So a lot of times in the sales agreement, it's going to require mediation if something would happen. And so you might want to waive that if the personal representative is out of state. And that's just, dealing with whether the personal representative would have to attend the mediation. The next question is, do you invest in the property? Do you sell it as is? So those are things that we talk to our executors about. Important to note, inheritance tax is a lien against the real estate until it's paid. So a lot of times closing companies are going to hold the money in escrow until we get the clearance letter. We're dealing with that in a case where we prepaid the tax to get the 5% discount. And the tax is all paid for, but we have to get the appraisement back from PA that says that it's been accepted as filed. So that money is actually remaining in escrow until we receive that back. And then if you have out-of-state property, it must be reported on the inventory. You're not paying Pennsylvania inheritance tax on it because it's not situate here in PA. And if it's not held in trust, then you may have to do an ancillary probate. Okay, so now let's talk about wrapping up the estate. So there are two ways to make distributions out of the estate. The first is at risk of the personal representative, and the second way is award upon final confirmation of the account. I would say most of the estates that we administer is number one, at risk of the personal representative. We're going to talk about that. So award upon final confirmation of the account, it's an adjudication of the account. So there's no longer a requirement in PA that you have to do this. It used to be you had to file it and get court approval. There's no longer that requirement. Now, the personal representative or the executor may be compelled to file an account at any time after the expiration of 6 months from the first complete ad or sooner if directed by the court. Now, that being said, the executor can file, I think 4 months is the earliest that they can do it. Doesn't mean they have to, just that's the earliest. And so a lot of times clients will say, what's the earliest we can wrap up the estate? The short answer to that is you can make some distributions at 4 months, but you're not going to totally wrap up the estate until you get that final appraisement back from PA saying that they've accepted all taxes that's filed. That can be about 4 to 6 months from the time you file that return. Okay. And right now, when we're dealing with COVID and some of the slowdown, we've seen a little bit of a lag in that. And we seem to get them in batches. So I'm not sure what's exactly happening with Pennsylvania, but you just kind of adjust to what's happening at the time. Now, an at-risk distribution just means it's a voluntary distribution. It's a family settlement agreement, basically. So what happens is any distribution that's not ordered by the court is considered an at-risk distribution. The personal representative does assume risk of distribution to the wrong people and is personally liable for lawful unsatisfied claims against the estate. So what that means is that when we make a distribution out to the beneficiaries and we haven't hit the 1 year mark from the first day of the advertisement, the personal representative is taking a risk there because, again, there's a whole year that creditors can come forward and say that they have a claim. And if you haven't waited the full year, then you are at risk. Now, here at our office, we just typically do a partial distribution, which means we hold enough back so that, we can address any of those concerns. But usually you can make a partial distribution. Personal representative is not liable to any creditors who have failed to give notice of the claim within 1 year of the first complete advertisement of the grant of letters. The personal representative can make written demand, mail or delivery, to any person who may have a claim who hasn't given notice of it. Demand may request written notice of a claim be made within 60 days from the mailing of the demand or 1 year after the first complete ad, whichever is later. If the claimant fails to respond, then they forfeit any right against the executor or the personal representative or property distributed and loses the right to be notified of the filing of the account by the personal representative. That's why that year is so important. Again, it doesn't mean you can't make a distribution. It just means that everything is not free and clear until the 1 year mark. Now, usually Tammy and I know, pretty soon after we run those advertisements that there might be a claim out there. And so we, address that accordingly. A real property, a claimant, so a person who's, has a claim against the estate must file a written notice of the claim with the clerk of Orphans Court within 1 year after the decedent's claim to preserve the claim. The claim against real property expires at the end of 5 years following the decedent's death unless within that time the personal representative files an accounting or the claimant files a petition to compel an account. So all of this deals with estates where there are claims. Now, a lot of the ones that Tammy and I are dealing with, we have two categories. So the first is that there are claims. There's also a huge DHS claim. And a DHS claim is when somebody was in a long-term care facility at the time of their death. So Pennsylvania has an order in which people are paid when there's money there's debt. So what happens is, there's the administrative fees, attorney's fees, personal rep fees, filing fees. Then what happens is there are things like funeral expenses that can be paid. And then pretty much after that, we have the Department of Human Services. So any care that they received, DHS would get the rest of that. So I would say we either have an estate that falls in that category, and then once it's paid to DHS, all the other creditors were below that, so they just don't get paid. That's one way that it's handled. The second way is that we're dealing with the complete opposite, which is the person never received long-term care. So we might just have a couple of medical expenses that were incurred within 6 months of the person dying. So we're just paying those off and then making the distribution to the beneficiaries. So I would say those are the two main estates that we're dealing with right now. They're kind of polar opposites. And we can make a voluntary distribution in the situation where we're paying, the expenses. So how we do that is that we do that with certain documentation. So there's a receipt, a release, and a refunding agreement. So what the receipt is, exactly what it says. It's disclosing, what accounts, what assets do we have, kind of receipting everything, what's coming into the estate, what's going out of the estate, what was an asset, what are we paying out as debt or income that's earned on those assets. Then we have a release that's saying that when we make this distribution to this person, if it's, not a year yet, so what we're making a distribution now, and we do that a lot, it's just saying that when that beneficiary receives the money, they're releasing the executor or the personal representative of any liability. And then the last thing that's in that agreement is their beneficiary is agreeing to refund. So if either the tax wasn't appropriately calculated or there'd be any other reason that a refund would be needed, the person who's receiving the distribution is agreeing to refund it. So in order for that to work, we have to properly recite the facts. We have to disclose everything that's been done on the estate. And then we have to allow the person to sign off on that, okay, and review it. We usually have an accounting that goes along with that so that people can see what went in, what went out. And the personal representative or the executor may file copies with the register and recorder. Clerk reports made to any person who receives an at-risk distribution, but filings do not constitute court approval. So you can distribute, have a release, and have everybody sign it. You can file that just as like a matter of record, or you can file it as a formal accounting, which is one step farther, okay? So when an accounting is filed, you need to consult with Pennsylvania statute, with the Supreme Court Orphans Court rules, the local Orphans Court rules, because there's certain things that have to be in the form, there's certain consent, there's certain notices, and there's certain certificate of notice. You have to make sure all of that's in there. If you have a charity, the Attorney General might need to be served in order for that. If you had somebody who died while residing in a state-maintained facility, you have to notify the Commonwealth Department of Revenue. If the personal representative knows that the person received Medicaid during the last 5 years of life, they're age 55 or older, you're going to want to send something to DHS. too. And then we always also notify the DMV and the 3 credit reporting agencies. Now, that doesn't mean we file an accounting with all of these. Again, typically we send a draft of the inheritance tax return and the accounting to the Attorney General. And with DHS, when there has been somebody who has died in a facility and was receiving long-term care, we do have to properly provide, how were those funds spent? We have to disclose all of that. DHS can advise the personal representative any amounts received and entitled to recover. So we get a letter that says this is the amount that we're owed. In one case, the estate wasn't that much. In that case, we were auctioning off property. So we actually had to work with our caseworker at DHS to make sure that the auction was the appropriate way. They were okay with that. And then we had to get them to agree to the value that we used. Okay. So the reserve that we were doing, we had to get them to agree to that. Commonwealth does receive notice if interest as statutory heir and unresolved inheritance tax issues. So again, Pennsylvania does have the right to receive certain things if, depending on the intestate statute, they're far down, but they could be beneficiaries. The Veterans Administration needs to receive notice if the decedent was a veteran or a minor of a veteran that was receiving benefits. Mm-hmm. The account must have a state of proposed distribution. We have to serve a copy of the statement with the account to all parties in interest. The personal representative has to file a petition for adjudication with accounting if they want to do that. They have to check the local rules. And when you do that, you can also ask the court to decide certain things that you need. So, for example, if we had some creditors and we only had X amount of money, but we had creditors and that amount exceeded, we might have a proposed distribution and then ask the court to sign off on that. Okay. Consult local rules to determine when a decree of distribution or adjudication relating to account becomes final. So how long do you have to wait? And so there are times when you can file, and then it lets you know when you're going to receive that final rule. In our office, we very rarely do final accountings where we're filing with the court because we can do it with just everybody signing the receipts and releases. Okay. So a final account, we always prepare one, even if we don't file it. And that would be if, we even prepare it if we're doing an at-risk distribution, which means that we're using the receipt, release, and refunding agreements. We still do an accounting, we just keep it in our records. The release of liability is only good if actions of the fiduciary disclosed. That's why you have to disclose all the distributions, everything, related to that and what each beneficiary is getting. And the accounting is going to show what property there was, what happened to it, and what is left. You're going to begin with the assets that were in the estate, and they're going to separate what's principal from income. We're going to show all the receipts of what came in and came out. We have some schedules that show what items are paid out of principal, including any distributions out to the beneficiaries. We're going to have income schedules. We're going to show payment out of income, and then we're going to show any balance on hand. So in our office, we always keep a reserve amount just until we get that final appraisement, so that if there are any other things that come in, we have funds to take care of that. And again, it's usually it's not more than $5,000 depending on the value of the estate, but we may say we're going to distribute everything, but we're going to keep back X amount just in case anything comes back for the appraisement. All right. So transfers within 1 year of the date of death are subject to Pennsylvania inheritance tax. They do allow a $3,000. So if dad transfers $10,000 to me within a year of death, it's $10,000 minus the 3. So I pay tax on the $7,000. We are doing a lot of virtual probates, which is one thing that I wanted to talk about. So we can do them right here in our office. They just give us a link. We have to provide all of the documents to the registrar and recorder's office. And then at that proposed time or that scheduled time, we all jump on our computers. The executor gets sworn in, signs everything. We send it up to the registrar and recorder's office, and then we get the short certificates. So that has worked really well. We've done it here in Franklin. We've done it in a couple surrounding counties as well. It's working really well. We do send date of death letters to institutions so that we can get that on their letterhead or on their statement. So we have that. And then another thing I wanted to mention is that in this area, we have a lot of clients who transferred their house for $1 to their kids, but they still continue to reside there. And they do that because they think it's not subject to inheritance tax. And in Pennsylvania, it still is. It's what they call an applied life estate, and it's still going to be subject to Pennsylvania inheritance tax. And I feel like that last couple of bit, I really whizzed through those slides. So I wanted to close our next virtual seminar. We're waiting until after the holidays, so it's January 28th in 2021 at 12 p.m. And hopefully by then we'll know some tax updates as to what's happening with the state as well as federally. So we're doing keep your seatbelts fastened until we reach a complete stop dealing with the tax updates. You can call our office at 717-655-2676 or email Amy at that email address there to register for it. We do record all of our seminars and then we post them on Facebook and on YouTube. So if you missed anything or if you want to go back and look at our other seminars, you can always do that. And Amy typically does email a link for a survey just to give us feedback on the seminar. If there's anything you want us to cover more in depth, we're happy to do that as well. So always feel free to give us some feedback. Okay, so now we're going to go to questions. So I'm going to stop sharing my screen. And what questions do people have? So I see, so Tammy put in a chat box, says PA recognize common law marriages anymore? And the answer to that is no. After 2005, Pennsylvania no longer recognized common law marriages. So that's a good question. If somebody's not legally married, in Pennsylvania, we don't recognize common law marriages anymore. Thank you, Tammy. What other questions do we have? It's a quiet bunch today.
Very interesting. Bob Finch here. Very interesting presentation. It's mind-boggling. I don't know how you deal with all that stuff. But I am glad someone is around like you who can handle it. But
yes.
No, good presentation of some.
Well, thank you. I always appreciate
very detailed stuff.
Well, I wanted to do more detail. Last time we kind of skimmed over it, and so I wanted to give some more details about how it works here in our office because we get so many questions about how probate or how the administration process works. And I think a lot of people don't realize all the little things that go into it, and that's why it can take a little bit. Now, that being said, Tammy and I can usually finish up an estate, well within the 1 year. So if you know somebody or have a situation where you have had an estate that's drawn out longer, you might want to kind of gently nudge that attorney and say, hey, can we be making some sort of distribution in this case? Yeah. I appreciate your feedback. It's always good to see you and Louise. Are you guys doing well?
Yeah.
Good.
Haven't tested positive.
Have you guys been staying in most of the time?
What?
Have you guys been staying in most of the time?
Yeah, the only time we go out is to pick up groceries at the curb or go to doctors or dental appointments. Everything else we do in-house.
Absolutely. Okay, I have another question in here. It says, perhaps this is future idea, how to deal with wills, distribution of multiple rental properties. Yeah, maybe we can do a whole seminar on, dealing with rental properties. I can see all kinds of fun things we could do with that. So thank you, Emily. I will do one like that for sure. Does anybody else have any comments or questions? Okay, I'm going to